the Court of Appeals. We have two oral arguments scheduled this morning. The first one is People v. Aldridge. I see counsel is seated and ready to go. The second one is Digital Landscape versus Media Kings. Are counsel here for that case?
Yes, sir.
Okay, we'll hear argument second in that case. I know that most of the, if not all of the counsel are experienced, but I'll just review briefly that, as you know, you have 15 minutes for the oral argument for each side. We have our traditional color coded timers that start out green and turn amber when you have 5 minutes left and red when your time is over. You can adjust your time accordingly. We also have the digital timers that you can use to help you plan your time. If you'd like to remind you of a particular amount of time for rebuttal argument, I'd be happy to do that. You should know that we've all read the briefs and we've had a chance to review the record, so you may wish to focus your argument on the legal issues rather than the facts of the case. As I think you all know, our oral arguments now are live streamed, so if you have any confidential or private information, you may wish to be careful as to how you refer to it. You should also know that you can raise or lower the podium to suit your convenience. And finally, I would ask everybody, if you have a cell phone with you, to make sure that it's turned off so it doesn't interrupt us inadvertently during the oral arguments. And with all of that having been said, we're ready to begin.
May it please the court, my name is Mark Evans, number 40156. I'm a public defender here today representing Mr. Robert Aldridge, and I will aim to reserve approximately 5 minutes for rebuttal. I'm happy to answer this court's questions about any of the issues raised on appeal, but what I'm planning to focus on today is the one trial right that in many ways is the foundation for all of the others. When the state charges someone with a crime and sets about convincing jurors that they're guilty, that person has a fundamental right to be there. If a person's not present for their own trial, or even just a critical stage of their own trial, all of the other trial rights, confrontation, counsel, the right to testify, can all be rendered effectively meaningless.
Can I ask you a quick question? Because everybody concedes that what the trial court did here didn't comply with the statute under the circumstances. Where, if the statute were to have been complied with, where is everybody?
So, Your Honor, what the statute authorizes is it says that the child witness testifies from another location, and it says that the people who may be in the room with the child witness include the attorneys, a GAL if one's there, someone to assist the witness, and the jury.
Does it say the jury would be there? That's what I'm confused about. It seems unclear to me that that's what's required. And actually, I think it's Rodriguez that indicates that that is not the case.
Correct. Rodriguez does say that. I saw that in Rodriguez. I went back, I looked at the statute. I believe that the statute authorizes but does not require the jury to be there. It lists the people who may be in the room with the testifying witness. And I think part of the confusion may be there that in the cases that have upheld the constitutionality of the application of Colorado's statute, cases like Phillips and Ujamaa, I think what happens in practice most of the time is that it's just the child witness and the attorneys who go to the other room and testify remotely. And
Is that compliant with the statute in your view?
Yes, Your Honor, because the statute doesn't list people that shall be taken to the other room. It lists people who may be taken to the other room. And if you're just removing the attorneys and the child witness, then you don't end up with the right to presence problem present here.
Okay, so under those circumstances, the trial is going on where is the trial going on? And it seems like an odd question, but when the judge and jury are in different rooms, where's the trial?
So in the cases that have upheld this statute, like Ujamaa and Phillips, it's just like a normal trial. Everybody is in the courtroom. The only thing that's changed is that the witness and the two attorneys have moved elsewhere. So I think that the trial is clearly taking place in the courtroom.
Because the judge and jury are together.
Because the judge and the jury and the defendant are all there. And when you look at the statute, what the statute authorizes is those listed people in subsection 2A to go to a separate room. So I think that that is the only part about the trial that changes.
Mr. Evans, as you know, the statute contains an exception that allows the defendant to be in another room rather than the children. Do you think that the provision in the statute about the jury being present is intended to apply to that exception?
I think that when the statute is applied, as it usually has been applied, just moving the witness and the child out of the room, that provision saying that the defendant can only be removed from the courtroom upon stipulation is what avoids the constitutional right to presence problem. Because if the defendant stipulates to being removed instead, then he's waived.
Right, no, but what I was referring to was that if there is such a stipulation as you're describing, then the child witnesses would testify in the courtroom, and then the jury presumably would be present.
Correct, Your Honor. I think that's correct, that upon stipulation, exactly what happened in this case can happen.
Pardon me for interrupting, Mr. Evans. Sorry to hit you so quickly with stuff right out of the box, but it strikes me that the reason for allowing a child to testify remotely in most instances is a concern about the emotional effect of testifying in the presence of the defendant, the physical presence of the defendant. Now, obviously, that is not enough to overcome a constitutional right, but it certainly is enough to allow for some rearrangement of the furniture, so to speak. In what circumstances do you think it would be permissible for the court to set up an arrangement like it did here? And for example, let me add one fact. Let's assume for purposes of argument that it would be very physically difficult to make the arrangement for the child to be elsewhere, and that the best way to work it out physically would be for the child to be in the courtroom.
So, Your Honor, I don't think that there is a situation where that can happen. I mean, the seminal case on this, Maryland v. Craig, really just talks about the confrontation right. It doesn't address the right to presence, and the law is pretty clear that the only person who can waive the defendant's right to be present is the defendant. Now, of course, the defendant can waive it through misbehavior or any things along those lines. But and even Colorado's case law is very clear that the closed circuit television statute represents the General Assembly's best effort to balance the interests of society in protecting the child witness and the constitutional rights of the defendant. And I'm unaware of any case law saying that the defendant's right to be present for his own trial can be waived based on the societal concern with child witness testimony. I think that, and it's difficult for me to imagine in 2018 a courtroom that doesn't have the ability to figure this out one way or another from a technical perspective.
You haven't traveled to the rural parts of the state.
Yeah, pardon me for interrupting, but I've had occasion to be out in rural Colorado recently. There are some courthouses where this would be very difficult.
Well, and that may be the case, Your Honor, but certainly, just based on what happened in this case, had the same setup and arranged, and the witnesses and the attorneys gone to chambers and they set up a communication link there, that would have been constitutionally permissible.
So, and I hate to keep going back to where is the jury supposed to be under the statute absent a stipulation? Are you conceding that the statute is ambiguous as to that? So in compliance with the statute, they could have the jury go over with the counsel and the witness and actually observe over there without a stipulation. Is that permissible under the statute?
Your Honor, I believe that is permissible under the language of the statute.
Okay.
However, had that occurred, I would be here making the same constitutional right to presence argument.
Because now I'm going to go back to my question and make you answer
Right.
it. Where's the trial happening? When the judge and the jury are in different rooms, where's the trial happening?
The trial is happening where the jury and the defendant are.
Okay. No, you can't tell me the trial's happening where two of the participants are because they may end up in different rooms. So the trial is happening where?
So most of the cases talking about the constitutional right to be present are talking about when there's a communication to the jurors. So it's in that time when you have the jurors and the defendant and presumably the judge together that is the place where the defendant has the right to be.
Okay. So if you're conceding that under the statute, the jury could be in either place. Now, you say you'd be making the same argument, but they, under the statute, could be in either place. Why isn't this just a problem then of labels? Why can't we call the judges' chambers the courtroom and the courtroom the judges' chambers, and everybody that was authorized to be together was together, and therefore we really don't have a problem other than labels?
No, Your Honor, the people who had to be together weren't together, because what the cases talk about is that communication that occurs between the accused and the jurors. And it's that was missing in this case.
So you were saying that that absent a stipulation, the jury is required to be in the same room as the defendant?
I'm saying that if the jury is not in the same room as the defendant, absent a stipulation, you have the constitutional right to presence question.
Okay.
Correct.
All right. I just wanted to make sure I understood your position. Thank you.
Absolutely. And it's that communication between the jury and the defendant that's critical here. It's when the doors to the courtroom opened, when the alleged victims came in, when they walked up to the witness stand, and when they uttered the words in real time that Mr. Aldridge had sexually assaulted them, the juror's natural inclination was to look not just to the testifying witness, but to look at him. And assessing his reaction to the alleged victim's accusations was just as critical to jurors' evaluation of this case as was their assessment of the testimony itself. And that's human nature. If you hear someone being accused of something terrible, you look to that person to see what their reaction is. And that reaction means something to us.
And where's that constitutional right contained? What is that constitutional right?
Well, the right to be present in court flows from both the Sixth Amendment and the Due Process Clause. But where you get that articulation of what I'm expressing here is in cases such as Payne from Colorado, Larson, Fontenez, Krieger. All of these cases talk about that psychological impact that the defendant exerts on the jury. And this isn't a case where we have to speculate about whether that psychological impact would have been there, because the court witnessed him have a breakdown so severe that the court interrupted the prosecutor, stopped the proceedings, and sent the jurors out of the courtroom. And had jurors witnessed that outpouring of emotion, surely it would have impacted their evaluation of the evidence in this case one way or the other.
Mr. Evans, I know you said you'd like to save 5 minutes for rebuttal, and you have less than 4 minutes, but I also wanted to ask you a related question about the record. The briefs, and I'm going to ask Mr. Kaler this question too. The briefs are not very clear as to when Judge Barton actually made his ruling that the defendant would be in the judge's chambers along with the judge, unless I missed something. Is there something in the record that explains exactly when Judge Barton ruled and whether there was any objection at that time by the people or by the defendant?
Your Honor, how the judge intended to do things, I think, became clear at the end of the first day of trial, which is really just voir dire. Before I come up for rebuttal, I can get the page citation for you. But then the next morning, before the first day of evidence, we reasserted our objection to the procedure based on all the grounds expressed in the pretrial motion we had filed.
Right, I understand what you're saying, Mr. Evans, but I didn't see anything in the record where Judge Barton said, this is what I plan to do, especially given that the people requested something different from what Judge Barton decided to do. So are you aware of anything else in the record?
Your Honor, from my recollection, it's there at the end of the second day of trial that it kind of becomes clear. I don't think the judge ever said, this is what I intend to do. It more just started making references to what it was going to do.
Okay.
So I can provide that citation when I come back for rebuttal.
Okay, thank you, Mr. Evans.
Thank you, Your Honor.
May it please the court and counsel, Paul Kaler, 19210 for the people. Our position is that the trial court and the defendant need to be together, and that the witnesses, the child witnesses, the counsel and jury can be in the other room. Here, and our position is, or it appears that this was a convenience thing for the trial court because of the nature of this trial. Things were done in compliance with Maryland versus Craig. The trial court made the proper rulings, and therefore the procedure used.
In Maryland versus Craig, though, the judge, the defendant, and the jury were all in one room together, were they not?
I believe so, Your Honor.
Okay, so let me ask the question that I asked your colleague. Where's the trial happening?
It's happening in both places, I think. Under the procedures, because of the nature of the harm that would be inflicted on the witnesses, the trial was split into two different places. The trial judge was with the defendant, and everybody else could see the victims testify live. Under this, it's just sort of the nature of this problem. Defendant says, I wanted the jury to see my reaction, but the jury was also, if he had been with the jury, he could have said, I wanted the jury to see the victim or the witnesses' reactions as they testified. It's sort of this, it's a conundrum of this particular situation. But the U.S. Supreme Court and this court in Phillips addressed the situation that when the proper findings have been made, the trial can be split into two different places.
Right, but all of those seem to indicate that the proper procedure, absent a stipulation or concession by the defendant, is that the jury, the judge, and the defendant are all in the same room, and everybody, the jury, the defendant, the court, and the public, presumably, also observes the child through the testifying witness through the television. And granted, all the difficulties in assessing credibility that go along with that are just there. But they have that opportunity to observe both the defendant and the child. In the system that was used here, there was zero opportunity, not even just a constrained opportunity to observe the defendant, but no opportunity to observe the defendant, though they had a full opportunity to observe the witness. Where has that procedure been countenanced as appropriate in the absence of a stipulation?
Well, it's not, I'm not aware of a case that has okayed that, but I haven't seen a case where it says that is improper. Of course, usually the situation is, as we've been talking about, the judge and the defendant stay in one room and other people move to another room.
Right, because there you only have one constitutional right that you're talking about, which is the right to face-to-face confrontation. And that was you would agree that's the focus of Maryland versus Craig, right? Now you've actually created, by separating the jury from the defendant, you've created two constitutional problems. You have the face-to-face confrontation issue and the lack of presence issue. And it doesn't seem as though Maryland versus Craig said that interest gets to yield.
Well, I think we have to look at the general nature of most right to presence cases, like in Stackhouse, where the defendant went back to the jail cell without the proper waiver procedures. Right to presence cases involve the defendant not being part of the trial at all, being taken away somewhere else. Here the defendant was with the trial judge. The defendant was still part of the trial. He was not denied his right to presence. He was still part of the procedures that were proceeding.
They could not witness his reaction to that testimony at all, not even in a limited way. And in fact, here, something happened that the jury was completely in the dark, and it happened during trial.
I know, and that reaction could have cut both ways, Your Honor, of course, right?
Sure, but that...
Yeah, it's just the nature of this procedure where the defendant and the witnesses are in different spots. if it's not a presence problem, although we're not conceding that, because we think that where the trial is being split into two separate places, it's still one whole trial. There's always going to be a little bit a cut going either way. But in Maryland versus Craig, the Supreme Court said, in these special situations where there's a danger of the child witnesses being harmed by direct face-to-face confrontation, as long as the trial court makes the appropriate findings, the witnesses don't have to do that.
Pardon me for interrupting, Mr. Kaler, I'm sorry, but yes, I agree with you wholeheartedly that that's what Craig talks about, is the concern for the child's welfare in a face-to-face confrontation with the defendant. But in this case, we were not, that wasn't necessarily the only thing that was being affected. In this case, the defendant's right to be present before the jury was being affected. And there's no indication that the defendant has done anything that would get him out of the courtroom.
Right.
He hasn't misbehaved, you know, he hasn't done anything that would require him being removed. And so my concern here is that I don't know that Maryland versus Craig is the right analog. It certainly allows, it talks about the confrontation as far as the child is concerned, but I don't know that it talks about the concern for what's happened, what the defendant has lost here. We know that the defendant can lose, I put that in quotes, lose his or her right to be in the courtroom with the child. But no case that I know of has told me that the defendant also loses his or her right to be in the courtroom with the jury.
No, I certainly can see that, Your Honor, that the case law does not address this, but it falls under the statute. The constitutionality of the statute, I don't think was attacked below. The procedures were objected to, at least to a certain extent, but the statute itself was not attacked.
So,
This-
Mr. Kaler, let me ask you at this juncture the same question I asked Mr. Evans about what does the record show about when Judge Barton actually decided to use the procedure that was used in this case?
I do not know, Your Honor.
And is there any indication about whether the people ever objected to Judge Barton's decision to have the defendant join him in his chambers during the trial, given that that's not what the people requested?
I cannot answer the question yea or nay, Your Honor. As this court knows, it's a paper record. I did not review that part of the record when preparing for this argument. I apologize for being of zero use on that issue.
Do you think that there might be something missing from the record as to when Judge Barton decided to use this procedure? Some explanation, or do you think he just, as Mr. Evans suggested, that he sort of intimated at the end of voir dire that this is what he was going to do, and then the next day he said, okay, here's what we're going to do, and then that was it?
I always hate it when people say, usually not me, the court could remand the case for further findings from the trial court if the record is unclear, but maybe that's the appropriate situation in this case. And further explanation as to why the trial court used this particular procedure where he and the defendant moved to, I believe, chambers and everybody else stayed in the courtroom. I think the court rightfully recognized that what is easy to do in metro jurisdictions may be very difficult to do in rural jurisdictions. I remember one case where the jury selection process involved everybody on the jury panel, on the veneer, knowing defense attorney, the prosecutor, the defendant, the victim, almost all witnesses. And that is just the nature of rural counties. They do not have the space, they do not have the financial resources.
Doesn't the statute contemplate if you can't comply with the statute because the technology's not available, you don't get to do it? That's the remedy under the statute.
Yeah, I think, well, this is not really a technology thing because they could do the videotape back and forth. It's more of, it appears that it was more convenient or possible to have the trial judge and the defendant move to chambers, I believe, and have everybody else stay in the courtroom.
But you agree that's not authorized by the statute absent a stipulation, correct?
Not specifically, no, Your Honor.
I mean, because you can see that the statute wasn't followed.
Right.
And is your concession that the statute wasn't followed, just that the people that should have been in the courtroom were in chambers and the people that were in chambers should have been in the courtroom?
It was substantial. The people that were supposed to be together were together, both the defendant and the trial judge, which is what is required, and then everybody else could be together. So not as far as everybody that was together everybody that was required to be together was together. They were just not in the places contemplated by the statute.
Okay. And why, you're probably the wrong person to ask this, but why does that matter? If one's in, if,
It doesn't matter at all, I don't think, Your Honor.
Well, what about the cases that hold that the defendant, that is, has, the defendant's presence is important for the psychological effect that could have on the jury?
I certainly recognize, though, that one of my colleagues, long retired now, referred to those as the hairy eyeball cases too, so that the defendant could be staring at the jury as it occurred, and that the exerting psychological influence. I've never been really wild about those cases. They seem a little bit overstated, but
Well, whether
it's
you
just sort of, it's a situation, either the jury's gonna see the defendant live, or the jury's gonna see the crucial witnesses live.
Well, whether you're wild about it or whether we're wild about it or not is irrelevant. If I'm just asking in light of the fact that various courts have so held.
None of them are binding on this court, Your Honor. They're all, well, the one I remember most is a 10th Circuit case, is what we call the hairy eyeball case, but it is not, they're not binding on this court. None of these cases are binding on this court.
you're calling this kind of a zero-sum game. Either the jury's going to be compromised in assessing the witness or going to be compromised in assessing the defendant. But it's not a zero-sum game. Either they're going to be somewhat compromised in assessing the witness with the ability to fully observe the defendant, or they're going to be able to fully observe the witness and not see the defendant at all, right? I mean,
I guess
so it
that's
is not
true,
a
Your
zero-sum game. This is not some Hobson's choice that we're left with here, right?
I think so, Your Honor.
Okay, and let me just, the statute itself, you contend that the statute, absent a stipulation, authorizes the jury to be in either place?
Yes.
Because you certainly concede that the statute can be complied with and have the defendant, the judge, and the jury all in the courtroom, is that right?
Right.
So how does the decision get made as to where the jury is?
Well, I think it's a matter of discretion for the trial court. The trial court is aware of sort of the structural limitations on the courtroom, and granted, it may be better to move everybody off-site or move to the next room or to a jury conference or a jury conference room, but the physical limitations of that may make that impractical.
So you're saying the statute allows the physical constraints of the trial to end up dictating where the jury is, which it seems to me pretty critical to this procedure, where the jury is. And there's no presumption that the jury will be in one place or the other. It's just sort of up to the judge to sort of look at where they'd be most comfortable?
Well, I wouldn't go that far, Your Honor. The statute, the limitations of the statute are that the defendant and the trial judge have to be together. The witnesses can be in a separate place, a different room. Counsel and the jurors can be either place. And here, the trial judge chose one way. I'm
Well,
not.
counsel's always with the witness, aren't they? Contemporaneous cross-examination.
Right, you're right, Your Honor. Yeah, it's just, there are physical limitations. Trial judges have to have the authority to figure out how best to effectuate the goals of the statute while protecting the victims from the harm that Marilyn Craig versus Craig says is an appropriate consideration.
Do you agree that presence is a distinct right from confrontation?
Oh, yes.
Okay. And but you don't concede that presence was violated here?
We don't
Or
concede
do
that
you,
at all.
or is it your contention that this statute requires both presence and confrontation to yield under appropriate findings?
No, he was present during his trial, Your Honor. He was not
He was not absent in your view?
He was not absent. guess that's all I have. I
Thank
the
you,
court for
Mr.
its
Kaler.
attention.
Judge Topman, in response to your question about when this decision was made, what my notes reflect is that it was clear at page 283 of the transcript of September 29th, 2014, that's the voir dire day. The very next day, September 30th, page 4, we object on the bases stated in the motion, which include that the right to be present isn't satisfied by watching your trial on TV. But then I think when you look at the portions of that same first day of evidence, kind of leading up to when CO started testifying, beginning at about page 133, I think what that reflects is that the court has been working behind the scenes with its IT department to figure out how to make this happen. So, I mean, can I point to a precise moment in time when the court made the decision? No, but I think that it was at the end of that voir dire day that it became clear to the parties, and that's, shortly thereafter we reasserted our objection. Judge Welling, you had asked if there's a case saying that it's improper to do this. Yes, Rodriguez is the Colorado case, and then Price from Kentucky and Kruger from Michigan do as well. Judge Welling, you had asked whether the statute authorizes kind of something like this to happen in the absence of the available technology. No, it does not. Subsection 1 of the statute, 1A, lists conditions which must be fulfilled in order for this to be authorized, and having the equipment available for such use is one of those conditions.
Did you challenge the constitutionality of the statute? Or why didn't you challenge the constitutionality of the statute?
So I don't have to challenge it on appeal because the statute wasn't followed. And so, I can just say there was a violation of the statute and that led to the violation of the constitutional right. Had this taken place, with the jury separated from the defendant, then I would have been in a position of challenging the constitutionality of the statute as applied on appeal. I think that the motion that we filed in the trial court does not say unconstitutional on its face, but I think that what it says is doing what the prosecution is proposing to do here would violate several constitutional rights. If this court has no further questions, I would respectfully ask that it reverse Mr. Aldridge's convictions.
Thank you, Mr. Evans. Thank you, Mr. Kaler, again. We appreciate your excellent arguments on this difficult issue. The case will be under advisement, and a written opinion will issue in due course. After counsel have gathered their belongings, counsel for the digital landscape case can set up, and we'll hear oral arguments in that case. Mr. Connolly, whenever you're ready.
Yes, good morning, Your Honor, and may it please the court. Sean Connolly, number 33600 for the appellant, Digital Landscape. Our appeal raises three independent challenges going not to the merits of an arbitration award, but to the arbitrator's core power to do what she did. First, the arbitrator exceeded her jurisdiction under a narrow arbitration clause governing disputes arising under the contract by resolving a claim that, in her own words, was not grounded in the contract. Second, even apart from that limitation on arbitration, the arbitrator reached out with no notice, sua sponte, to decide a claim that had never been pled, had never been tried, and was decided for the first time and raised for the first time in her award. And third, even apart from these limits on her ability to decide the issue and decided sua sponte, the arbitrator improperly denied fees to my client, the only party who prevailed in an action to enforce the contract. I'm happy to discuss it in that order, but also happy, obviously, to address any questions at any time on any one of those 3 points. The first argument involves the scope of an arbitration clause that provides for disputes arising under the agreement.
Pardon me for interrupting, Mr. Conley. Based upon the looking around that I have done, it appears to me that there are 2 different views of viewing arising under in this country. There are Mediterranean and other cases from the Ninth Circuit. Then there are cases from the Second Circuit, and of course the case you mentioned from the Federal Circuit. But the cases from the Federal Circuit all come from a case called Kinoshita, I think. If I'm pronouncing it incorrectly, I apologize. And even the Second Circuit has backed off Kinoshita a great deal. And there are at least, by my count, 4 or 5 other circuits that have said, we disagree with this view of arising under as expressed in Kinoshita. And Kinoshita really mattered in Mediterranean enterprises. So understanding that counting isn't, the ultimate way that we make decisions, but there's a big split, isn't there, about the scope of arising under?
Your Honor is correct, and I think your counting or the layout and the history is accurate. There's one thing I think is omitted that I think is important. In 2010, after many of these cases, the U.S. Supreme Court, obviously not binding on this court, but in this matter of contract law, but certainly in terms of arbitration clauses, in Granite Rock in 2010, described an arising under clause as a narrow clause.
But again, pardon me for interrupting. That was made in I think the context of that reference is different. As I understand it, there was a citation to a case called Drake Bakeries. And in Drake Bakeries, the clause in that case not only talked about contractual things, but conduct. It was a labor issue, and it had to do with the conduct of people. And what strikes me as much broader than if we're talking about clauses in a contract.
You're right. The clause, and I think it might have been in a 63 case or so that Granite Rock cited,
Right.
and it was much broader than arising under, and they contrasted that clause. I think the Mediterranean and other cases that Your Honor's noted have contrasted our arising under clause with a clause that says relating to, arising out of or relating to, obviously a much broader clause. I think the key is we're just saying that words should have meaning. And arising under should not mean the same thing as arising out of or relating to. And their premise, and I think the premise to uphold this award that was by its own admission not grounded in contract terms, has to be that arising under is really synonymous with arising out of or relating to. Otherwise, and that's the latter clause, the broader one, is the AAA recommended clause. And that was made clear by City and County of Denver, our Colorado Supreme Court in '97. It's the AAA recommended clause. And our point is simply that arising under should not mean the same thing, should not be as broad as arising out of or relating to. And to
Mr. Connolly,
decide,
excuse me for interrupting. Wasn't the decision in the RPT case from a division of our court to the effect that the term arising under should be given a broad meaning?
It did. And I think that's incompatible with Granite Rock in 2010, which said it's a relatively narrow clause. But RPT doesn't control here because RPT was a dispute involving a contract, involving specifically the termination of a contract. And they said arising under, the holding, apart from that dicta saying it's a relatively broad clause, which I think is at odds with other cases, the holding there is perfectly compatible with what we're saying should be the rule. It involved the contract. It involved the, whether the contract continued and how the contract was or was not being complied with. Here, this counter award was solely an issue of a made-up, we would say, a sua sponte claim injected by the arbitrator about a duty of loyalty that arises not under the contract, but under agency law. And indeed, not only, and by the arbitrator's own admission, it was not a claim involving the contract or regarding the contract's terms. It was a claim that she decided contrary to the contract's terms. And again, we're not getting into the merits here, But she said the contract says this is an independent contractor relationship. It said that 5, 6 times. It called my client a contractor, an independent contractor performing an independent. She said, despite that contract language, I'm going to decide a non-contract-based claim and say that there was, in fact, an agency relationship here, even though the terms of the contract are at odds with that. So I think our first point, Judge Bernard, is we'd ask you to hold arising under does not mean the same thing, is more narrow than arising out of or relating to, and therefore it cannot cover the dispute. But if you disagreed with that, second is we have a fundamental right under Colorado law, under the arbitration statute, not to mention due process, to only have claims decided that were tried and submitted to the arbitrator. The claim that was, and the arbitrator rejected each of the 5 counterclaims that were asserted. The counterclaim number 2 that is at issue here was a claim for the implied covenant, a breach of implied covenant of good faith and fair dealing. She said that claim is not really established because this disparagement type claim that she ruled on is not grounded in contract terms. So therefore, I reject the claim that was pled. And then she said, nonetheless, with no notice, and the first time we ever heard of this breach of duty of loyalty claim was in her award. And she said, nonetheless, as a matter of agency law, there's a duty of loyalty. And that duty says you cannot disparage your principal. And we never had a chance to litigate, hey, wait a second, this is not a principal-agent relationship. This is an independent contract relationship. Look at the contract, and we could have put out evidence about that. Never had the chance to dispute that core element because the first time this claim is ever mentioned is in her award. That is contrary to the clear rule of Colorado that the only issues that can be awarded on are claims and issues that were submitted for arbitration. So even if you agree that this would otherwise be within the scope of this, I would say, narrow arbitration clause, even arbitral claims have to be given notice, have to be tried, have to be arbitrated. An arbitrator cannot say, I reject the claim that was pled, but I'm going to award for you on another claim. That's incompatible with Colorado law that says the only issues that can be decided by an arbitrator are issues that the party submitted to the arbitrator.
Pardon me for interrupting, Mr. Conley, but what about this language from City and County of Denver? That the factual allegations which form the basis of the claim asserted, rather than the legal cause of action pled, should guide the court in making the determination as to whether a particular dispute falls within the reach of the alternative dispute resolution clause.
And I accept that. Here's the problem. Here's why that was not satisfied here. Because there was, you can call it whatever you want, and they called it an applied covenant of good faith and fair dealing. This agency theory is a different factual allegation. It's a theory. One of the elements of this breach of duty of loyalty is that there's a principal-agent relationship. Now, that's at odds with the contract. I've talked about that. But that was never a factual allegation made to support this claim. The first time that there was ever any discussion about is this a principal-agent relationship that gives rise to a duty of loyalty is when the arbitrator issued her award. The counterclaims, they pled different claims, different elements. They never alleged even, factually, the factual allegation was never that there's a principal-agent relationship here. Had that been made, we could have amply refuted that. It's refuted on the face of the contract, for one thing, but that's a key element of the claim she ruled on that was never tried. So under City and County of Denver, even if you say we're going to look beyond the label given, the facts that were pled, principal-agent relationship, never pled, never raised, never tried. And when she comes out and says, I'm going to give a counter award on a theory and on a factual predicate that there's an agency relationship here, we never had a chance to try that. Imagine you're sitting, you get an award and say, well, we won on our claim, our contract claims, and we lost on a non-contract claim, but what claim was it? That there's a principal-agency relationship? I could have refuted, I the party, and the party's attorney, I was not at the arbitration, could have put on evidence, and would have put on evidence if they said there's a duty of loyalty here under Jet Courier, and one of the elements of that is that there's a principal-agent relationship. That could have been shot down very easily, but we never had a chance to do that. So that's the fundamental unfairness. Even if you agree that the contract was broad enough to allow that claim to be arbitrated, it was never arbitrated. And the first time you hear about it is when you lose in an award. That's just incompatible with any notion of fairness and process. And again, it's not, and it's beyond her power to do that. And finally, is the issue, there was only one party, the fee award. Those first two issues would say that you or the court should order vacated the counter award. Both of those would go for the full counter award and therefore would make us the only prevailing party for fee purposes. The third issue is, even if you kept in place this counter award on this duty of loyalty theory, the fee provision only covers actions to enforce the provisions of the contract. Now, Judge Bernard, we've debated on the two lines of theories, arising under, as broad as arising or relating to. There is no case that I'm aware of, and no split of authority, that if a provision says you get fees if it's an action to enforce the contract, that this extra contractual action was somehow an action to enforce the contract. So I think at the very least, even if you upheld the award on this extra contractual theory and it was never pled or tried, I think the fee award would have to be vacated because there's only one party that prevailed on a claim to enforce the contract and provisions of the contract, and that was my client.
But that's clearly, whether or not to award fees is within the power of the arbitrator, right? It's within the scope of, it's a contractual claim, right? Why isn't this just your argument that she got the law wrong? It's just kind of misapplication of the law that we don't peek behind,
Gotcha.
and that's something that happens in arbitration but doesn't get rectified on district court review.
McGinnis versus Brewer, 2008 decision of this court, said it was a matter of power. When there's a mandatory fee-shifting provision, that it's mandatory. And if you don't award fees when it's mandated, then it is a violation of power. It's not a merits issue. It's a core power issue. And I think given the language of the contract that says it's mandatory, any party prevails on an action to enforce provision of the contract, I think that both grants the power, mandates the power, and removes the power to award fees on something that's not an action to enforce the contract. I think it's a power issue rather than merits. I agree that that issue can be blurred a little bit. I think our first two are clearly power issues. This one is a little more on the dividing line. I think McGinnis, though, says it's on the power versus merits line.
But McGinnis, there was clearly one prevailing party. There weren't other claims that sort of muddied the water as to who might have prevailed. Here, the water's at least muddy as to who prevailed, even though you had a net judgment, and I understand your argument that yours is the only contract claim. Why isn't it just sort of a misinterpretation to say that no, there was no prevailing party?
Because I think it's a matter of power. The power, it mandates award to the prevailing party, and it limits the award to a party that prevails in an action to enforce a contract. The arbitrator said it doesn't limit it that way, and I think it's a matter of power. Can she award fees on a non-contractual claim? By her own admission, this was one. If I could save my minute and a half for rebuttal.
Sure. Thanks, Mr. Connolly.
May it please the court. Good morning, Your Honors. My name is Sarah DeDiego. I'm the attorney for the appellee, Media Kings LLC, registration number 37423. I want to start by addressing a few of the claims made by appellant. First, most of this case and their brief focuses on this idea that the arbitrator made up a new claim. At the end of it, that nobody knew about, she just came up with it out of thin air and threw this in. And our position is that is factually incorrect. This case went on for over a year and a half, concluding with a 2.5-day long trial during which the arbitrator heard extensive testimony from both sides. She had the chance to see all of the facts in the case. And based on those facts, she went through and had a very, very detailed opinion on an issue which we pled. In our First Amendment counterclaim, we made a claim for breach of fiduciary duty and the duty of good faith. In her opinion, you'll see under the heading of breach of the duty of good faith and fair dealing, she gave a lengthy analysis and she concluded that the duty of loyalty was breached by the plaintiff, or here, appellant. She did not make up a new claim. She simply went through her reasoning and ended with a duty of loyalty was breached under the claim which we made. And that claim arose from the contract. So the duty of loyalty arose from the contract. There was no other place for that duty of loyalty. The parties entered into a contractual relationship where the appellant, Digital Landscape, acted as the agent of Media Kings in conducting business with its client. And through that agency relationship, the independent contractor, as was pled in our First Amendment counterclaim and as the arbitrator and the district court noted, effectively stole the client by disparaging appellee to its client. And that is where the duty of loyalty breach arose. That arose from the contract. It's not separate or apart from the contract. And as the district court noted, it did arise from the contract. This was not a separate claim for duty of loyalty. We already discussed a bit, I believe, a few of the cases which cover this duty and whether or not it arose from the contract.
Pardon me for interrupting, Ms. De Diego, but I'm taking a look at the arbitrator's order here. And in subparagraph B of paragraph 24, it says that the assertion that Digital Landscape is liable to Media Kings for disparaging Media Kings to Transcendent and effectively sealing Transcendent as a client is not truly a claim for a breach of the implied covenant of good faith and fair dealing because it is not grounded in contract terms. That's what the arbitrator ruled.
Yes, Your Honor.
So the arbitrator was rejecting the claim, the duty of good faith and fair dealing claim. So what was the duty of loyalty?
I'm not sure, Your Honor, that she actually rejected it. She just said it's not truly a claim grounded in the contract terms, which, to be quite honest, I'll be completely honest, I don't quite understand this sentence in her ruling. That's just me being honest. I don't think, though, that she rejected it. She doesn't say explicitly that she's rejecting it. She just says it's not truly a claim grounded in contract terms. She doesn't say it's not or that she's rejecting that claim, but then she goes on to continue her reasoning and ends with the duty of loyalty as opposed to a breach of the implied covenant of good faith and fair dealing.
And her reasoning is based upon the factual allegations in the duty of good faith and fair dealing claim as pled, correct?
Yes, Your Honor, and I believe as well in just the facts of the case in general. It was a very extensive motion practice in the case and resulted in a very long 2.5-day trial where there was extensive testimony. She also...
Isn't the duty of loyalty claim predicated on a principal-agency relationship? Isn't that a necessary element?
Yes, Your Honor.
Where did you plead that there was a principal-agency relationship between the two entities?
I don't believe that the words principal or agency were used. However, in a relationship where you have it's grounded in the contract. The independent contractor is an agent of the company that it is providing services for when it is acting, as the facts of this case showed, the contractor was acting as the agent by dealing directly with Media King's client. They were the go-between. They were the face of the company for this contract. They were acting as their agent. They were doing nothing. There was no other relationship or other position that they were in during the term of this relationship. And those facts were, pled or I guess shown throughout the trial.
And you think the arbitrator just got it wrong when she said that this was not a claim not grounded in the contract?
I do think that she got that wrong. And I still, again, I'm not exactly sure it's what she was saying. I think her wording was a bit confusing. I will grant that. Her wording is confusing here. But she did go on, and she was very clear that the duty of loyalty did stem from the contract. Also in her award, I'll direct you to, I guess it's page 4 of her award. In a footnote, she said, Digital Landscape is not entitled to revenue sharing for July 2012, as by then, as addressed below, Digital Landscape had breached its duty of loyalty to Media Kings. And also, further on in her actual opinion, she said, the agent's duty of loyalty ends upon the termination of agency. It was in subparagraph H. And she goes on to, the reason that she only awarded my client 34, whatever, I think it was 24,000 plus interest, rather than the 750,000 plus that we were going for, was because she said that the duty of loyalty terminated as of the date that the contract terminated. She wasn't saying that there was a duty of loyalty separate and apart from the contract. She tied it in explicitly to the contract by saying that duty of loyalty ended the date that the contract terminated. Otherwise, if the duty of loyalty had extended past the contract termination, then I believe she would have awarded my client a substantially higher amount.
So are you saying that the duty of loyalty is a subspecies of your good faith and fair dealing?
Yes, I am.
Okay.
I wanted to address a couple of the cases that were discussed. Specifically, Granite Rock Company versus International Board of Teamsters, we believe is completely distinguishable from the facts of our case and the holding as well. That case arose, as Justice Bernard, you mentioned, that case arose from a no-strike dispute between a labor union and a company. And the issue was not whether or not the arising under clause allowed for it. It was whether or not the arbitration agreement was even in place as of the date of the dispute. The dispute, I believe, was on July 2nd. One party said that they didn't actually ratify the contract until a month later. So if the contract wasn't ratified until a month later, they hadn't agreed to arbitrate the dispute that happened a month prior to the contract coming into place. So with the facts of that case, their dispute did not arise under a contract that might not have even been in place. I think those facts are completely distinguishable in the situation from what we're discussing here, and I don't believe that it applies. Also, in the Mediterranean Enterprise case, which was mentioned earlier, in that case, the court did opinion that arising hereunder was narrowly construed. However, the court went on to find that allegations of breach of fiduciary duty fell within that narrow reading of the words arising hereunder. So again, I don't believe that that case particularly hurts us. In fact, I think it backs our position that arising under, which was the wording in our contract, covered these equitable relief which the arbitrator went ahead and awarded. And equitable relief is within the purview of the arbitrator. She has the ability to award equitable relief on a contract, and case law shows she has, the ability to award maybe even more equitable relief than a court would.
Ms. De Diego, in interpreting the meaning of the phrase arising under, is it enough for us to look at the Colorado arbitration statute, or is it appropriate to look to federal case law as well?
I believe it's appropriate to also look at federal case law. I believe this is an issue of first impression here in Colorado. However, as previously mentioned, other circuits have, extensively looked at this issue. And from the research we did, which is, obviously in our briefs already, it appears that, the courts are leaning towards supporting this presumption in favor of arbitrating disputes by allowing disputes to be arbitrated under even clauses that they're finding to be narrow with just the words arising under. Even if arising under is given a very narrow interpretation, though, we would still say that this duty of loyalty would fall under that because it arises from the contract. It arises from the relationship between the parties, which was through the contract, which is at issue here in this case. Another case which actually was already mentioned, which was the RPT Inc. Case, which actually is here in Colorado from 1996. And the court did decided that language was stated that any dispute that arises under, that was broad language, in fact said, thus, under the broad language of the arbitration provision here, the parties had a duty to arbitrate all disputes regarding the contract. That is the closest, to controlling law as that is from this. That is from Colorado, not from the Ninth or the Second Circuit. RPT also stated that the arbitrator is the final judge of both fact and law, and that is our position here. The arbitrator was the one in the position to decide both the facts and the law of this case. She extensively reviewed the facts. She was the one who was there. She saw the facts. She lays out in great detail how it supports the duty of loyalty, and she awarded that. And based on that, there was no prevailing party in this contract, or there was two prevailing parties, but neither of them was the clear-cut prevailing party. And based on that, she declined to award attorney's fees, which we, of course, believe was proper. May I answer any other questions? No? Thank you, Your Honors.
Thank you, Ms. De Diego.
In my brief time, I'd like to focus on the second argument we've made. The issue of whether there's a duty of loyalty depends on a finding and an allegation that there's a principal-agent relationship. Judge Bernard, you cited 24B, the arbitrator's paragraph, said it's not grounded in contract. 24C and D, she went on to say, it's grounded in agency law. And she said in 24D that despite the contract saying it's an independent contractor, I can still find that it in fact was a principal-agent relationship. And she cited, by the way, a dissent from the Colorado Supreme Court, ignoring the Colorado Supreme Court majority opinion, saying exactly the opposite. But even if she's right on that, this is a claim that was never pled. You can look at case file pages 80 to 84. That's the entirety of the counterclaims, the amended counterclaims. On count 2 of that was a one-sentence allegation that it was an applied covenant of good faith and fair dealing, much of which had to do with alleged solicitation, she said was not violated, alleged confidentiality violations found not violated, and one mention of disparagement, but no mention in anywhere in that allegation of a principal-agent relationship. This was an allegation, a finding she made up that was never pled, never tried, and never even heard about until the opinion came down. That's not due process, that's not fairness. On that ground alone, we ask you to vacate.
Mr. Connolly, you say it wasn't tried. Do we have the transcript of the arbitration hearing?
We don't. And my recitation about what's tried is you can look at her lengthy opinion, 11 pages, and she recites the trial evidence. Nowhere in there does she say that it was not pled. Let me say that. I can definitively say it was not pled in the 80 to 84 case file. My tried is based on my discernment from her opinion of what was tried and not. And what she said was tried was an applied covenant claim that she then converted. So your point's a good one, Your Honor, that it's an inference I'm drawing about not tried from there, but certainly never pled, and no indication in her opinion that it was ever tried. And the first we ever heard of the duty of loyalty, I can say with that, from the record, is her award, and that's just not kosher in our view. Thank you.
Thank you, Mr. Connolly. Thank you again, Ms. Diego. We very much appreciate your excellent arguments in this case this morning. The case will stand submitted and a written opinion will issue in due course. That concludes the oral arguments this morning for Division 1. The court will be in recess and the bailiff may so announce.
All rise. The court will be in recess, subject to call.
Yeah, I came out of the field, I had the record with record. I know. I could ask you that.
I noticed that just getting. Oh, it's not in there.
Yeah, yeah, I couldn't, I turned it over, the record was what it was.
Yes.
You coming from California, you still, you live in Jersey?
Well, he's not a career